Can you mention?
May I please, Your Lordship?
Yes.
I'd like to mention item number 11. My Lord, I'm seeking for 2 weeks' time, my Lord. It is a joint prayer from both the sides. It is a joint prayer from both sides.
16 meters.
Yes, my Lord.
On joint prayer made with the parties list after 2 weeks. Yes.
I will reach, my Lord.
Please, Lordship. I beg to mention item number 21, Your Lordship. Lordship, the conducting counsel in this matter, Your Lordship, is out of station, Your Lordship.
Yes.
No objection.
When do you want it?
After 2 weeks, Your Lordship.
That one on the prayer made copy of the petitioner list after 2 weeks. Yes.
Obliged, Your Lordship.
May I please, Your Lordship? Lordship, I beg to mention item number 25, Lordship. Conducting counsel is on leave, Lordship.
25. I have no objection.
When
2 weeks, Lordship.
25 to 2 weeks on the prayer of the petition.
Obliged, Lordship.
Yes.
May I please, Your Lordship? I beg to mention item number 19. Your Lordship, in this matter, we are supposed to file the objection as the respondent number 2. They have filed for substitute, so we need to file objection in that reply.
There's a miscellaneous application filed.
Yes, Your Honor.
My lord, I have no objection.
No, but then who filed miscellaneous application? What is this matter about?
The judge have filed respondent number 2, Your Lordship.
Filed miscellaneous application for implement
For
of?
substitute because it has expired for substitute with the different name.
Where is the?
She's not here, Your Lordship. I have taken
Wait for the matter to come up.
much obliged, Lordship.
My lord, item number 17, my lord. This is that romantic relationship matter.
Yes.
My lord, may I have this matter after 2 weeks, my lord?
Yes. Mr. Gore, any likelihood of disposal of the matter pending?
I don't see that because the president CJ also, my lord. I don't think he'll take up this matter.
Just make it 3 weeks.
Obliged, Lordship.
My lord, item number 13, my lord. I'm praying for 2 weeks, 2 weeks time, my lord.
This is what? This is that service matter?
Service matter.
No objection. On prayer made by Mr. Argun, London GA appearing for the respondents. Not objected with the London Council of the petitioner. List after 2 weeks. Yes.
My lord, item number 10, my lord. I have informed Mr. Sangresio, still pending in DB, my lord. There is already an order here.
Okay. Just check the last order. When shall we list it?
We'll have 3 weeks, my lord.
Just say, see that thing, and if you see that it's pending this thing, just correct it. Yes.
Deeply obliged.
Lordship, I beg to make mention for item 9, Your Lordship.
Yes.
Lordship, may I have it after 2 weeks, Your Lordship?
Why? Why?
So it's conducting counsel is out of station, Your Lordship. So
Yes.
No objection, Your Lordship.
But these are the thing is that things will go on like this. You see, the prayer of adjournment will come, and there will be no objection from the state. The matter will be kept pending. This is also the prayer of the petitioner, not objected to by learned GA. List of 2 weeks.
I oblige.
Yes.
Please, Your Lordship, I beg to mention item number 16. Here, Your Lordship, we have to, from our side, we need to file the additional affidavit, bring on record the deposition of the mother of the victim. But due to unavoidable circumstances,
Is there any order allowing you to file an additional affidavit?
yes, Your Lordship.
Okay.
On the order on the 17 September.
So you have not.
Yes,
Till now
Your
you have
Lordship,
not.
we are not ready, Your Lordship.
You have.
Kindly give after 2 weeks.
So you want time for filing additional affidavit.
Yes, Your Lordship.
No objection, Your
Is
Lordship.
that correct that there is an additional affidavit to be filed here?
Yes, Your Lordship.
Then, can you just Mr. P.K. Satil, Learned Counsel, appearing with the petitioner, please for and granted for the 2 weeks time for filing an additional affidavit in terms of the earlier order of this court.
Oblige.
List accordingly. Yes.
Please, Your Lordship. Lordship, I beg to mention item number 20. Lordship, this is a love relationship matter, Lordship. This is an appeal. This is based on a love relationship.
3 weeks. 3
3 weeks, Lordship.
3 weeks. 20. Yes.
Deeply obliged.
Please, Your Lordship. Sure, I beg to mention item number 24, my lord. For 1 week, my lord. I have informed the other side.
I am for the state respondent. No
Yes.
objection.
There's any private respondent here? No.
Yes, private respondent, sir.
Private respondents.
Yes.
Respondent number 5 and 6, Your Lordship.
Just see on the prayer made on behalf of the petitioner, list after 1 week. Okay.
Much.
May please, Your Lordship. Your Lordship, I beg to mention item number 14, Your Lordship. I
Yes.
pray this matter can come up after 2 weeks, Your Lordship.
No objection, Your Lordship.
You are for the petitioner.
Yes, Your Lordship.
This is a matter where some compromise was.
Yes, Your Lordship. Initially, there was a settlement talk, but
Settlement didn't work out.
Then why we are keeping it pending?
But I'm ready, my lord. State is asking time today.
Just in prayer of Nasai Lingua, Learned G. Pen with the state respondents, not object to the Learned Counsel of the petition. List after?
2 weeks, Your Lordship.
Yes.
Obliged.
Much obliged, Lordship.
May it please Your Lordship, I beg to mention item number 12. The learned counsel is indisposed, Your Lordship.
You are appearing for
For respondent number 1, 2, 3, and 6.
District Council.
Yes. KHDC.
Your Lordship, I'm appearing for response 7 and 8.
No objection, Lordship.
Just one prayer made on. Wait. Where are we?
Yes,
One prayer made on behalf of.
for the state.
Wait. Don't let the court pass order. Then why you are leaving before order is passed?
Oblige, Your Honor.
Yes. Give your name. Give your name, please.
M. Mouth.
Okay, Miss So and So, Learned Counsel. Appearing, Mr. T.T. Diengdo,
Yes, Your Lordship.
appearing on behalf of Mr. T.T. Diengdo, Learned Senior Counsel. Mr. So and So, Learned Counsel, appearing on appearing for the number 6 grant of adjournment of the matter by 2 weeks. Yes, Learned Counsel for the appearing of the petitioner has no objection. Prayer allowed, list for 2 weeks. Yes.
Oblige.
We'll start after coming there.
item number 1.
Yes.
Mr. Pandey is online.
Yes, Mr. Patel. Why? Why?
Item number 2, man.
These both are connected matters. Okay. Yes. Yes, please proceed.
Disbursal of amounts to the GHADC, Garo Hills Autonomous District Council, Milords, in 2015 and 16. And certain work orders were given to certain contractors. The allegation is that the advance amount has been paid to the contractors, which apparently is the contention is contrary to the notification. As far as Mulaks, the petitioner is concerned, the works which have been allocated to the petitioner, they were completed. But the issue, Milords, in both these matters is legal rather than factual, Milords, because it concerns the jurisdiction of the Lokayukta over one, contractors, two, Milords, officials of Garo Hills Autonomous District Councils, and three, Milords, how the proceedings uh, have been discharged by the Lokayukta in these matters, Milords, which is contravention of Section 20 of the Lokayukta Act. Uh, Briefly, if I may indicate, Milords, in this case, uh, if your Lordship comes to page number 193,
Yes.
yes, Milords. So, 193, Milords, what I am trying to indicate here, I am taking my third point, Milords, which is common to both the matters, as far as the procedure which has been adopted by the Lokayukta. Yeah, and before Milords, before I read page number 193, I may give your Lordship a brief background. That Section 20, Milords, is of the Act, and the Act, Milords, is also appended. If your Lordship wants to see the Act, that is also, Milords, they are appended with the petition, and your Lordship can find Section 20 at page number 69 of the petition itself.
Yes.
Yes, Milords. So the procedure, Milords, is delineated in this provision for procedure in respect of preliminary inquiry and investigation. And the first provision, Milords, is the Lokayukta on receipt of a complaint first decide whether to proceed in the matter or close the same. And if the Lokayukta decides to proceed further, it shall order preliminary inquiry against any public servant or by its inquiry wing or any agency to ascertain whether a prima facie case exists. So, my lords, first requirement itself is the Lokayukta to apply its mind and see whether to proceed or not, and thereafter hand over the matter for preliminary inquiry for determination of a prima facie case. Both these requirements, I may indicate, I will show your lordship the orders passed are not satisfied. Thereafter, my lords, point number 2 is during the preliminary inquiry, referred to in subsection 1, the inquiry wing or any agency shall conduct a preliminary inquiry and on the basis of material information and documents collected, seek comments on the allegations made in the complaint from the public servant and competent authority, and after obtaining the comments concerned from the public servant and competent authority, submit within 60 days of receipt of the reference a report to the Lokayukta. So the inquiry wing or the investigative agency will submit a report, my lords, in this case.
So this,
Now, my lords,
all these things were not done in this case.
my lords, all these things were not done, and in fact, my lords, if your lordship sees,
We'll issue notice then. Who's the here appearing for
my
this?
lords, what I am saying, I may just indicate one aspect,
Yes.
because that is very important in this provision. Your lordship just sees the aspect of provision
Yes.
3. I'm just coming to 3. A
Yes, please.
bench consisting of not less than 3 members, because later this was amended to 1 member, shall consider every report received under subsection 2 from the inquiry wing or any agency, and after giving an opportunity of being heard to the public servant, decide as to whether there exists a prima facie case and make recommendations to proceed with the following actions. Now, my lord, second, page number 70, investigation by any agency or any special investigation agency. So, my lords, once a complaint is made, thereafter a preliminary inquiry to determine a prima facie case and then investigation by an agency. What happens in this case, my lords, is this, that after the preliminary inquiry, the investigation is not done by any investigative agency. It is handed over to an investigating officer. Later on, the Lokayukta become dissatisfied from that officer, rejects his report, and says that my inquiry wing head will now supervise everything.
Officer is not a part of the agency.
He is not part of the agency, my lords. And there is a separation between the inquiry wing and the investigative agency under the Act. The inquiry wing is headed by a retired IPS officer. Retired IPS officer, even as per Act, my lords, cannot be made head of the inquiry wing because Section 11 says it has to be an officer above the rank of Under Secretary. So a retired officer, my lords, in black and white, drafts the investigative reports, and on that basis, my lords, the proceedings are pending against me before the special court. And if your lordship now in this context sees page 193, your lordship, that will become absolutely clear. 193. The page, my lords, I was earlier indicating to 193.
Yes.
Last third paragraph, my lords, the IO has submitted inquiry report dated so and so, and not the investigation report as directed. This is not expected from police officer of the rank of Deputy SP. IO should know the difference between investigative report and inquiry report. IO is directed to meet Shri so and so, Director of Inquiry and Prosecution Wing at so and so. That is, my lords, the first direction. Now, my lords, just sees the second direction at the subsequent page 194.
Yes.
194, my lords, last line, J. Rimbai, IPS, Director of Investigations, shall supervise and monitor the case to complete the investigation.
Yes. So what is the problem in it?
My lords, that is not a procedure which is contemplated under the Act, because the Act says the...
If any superior officer is directed to supervise, what is the problem in it?
My lords, first of all, he is not the superior officer.
We will see to it. Let the other side appear. Yes, sir. Madam.
My lord, for the state respondents, I accept notice on behalf of one, madam. In both the cases, madam.
Both the cases. My lords, what I am, because, my lords, there is an order your lordship has passed in the other matters also of keeping abeyance the proceedings before the special court. One of the orders, my lords, I have annexed also with the petition at page 250. Not 250. 256, my lords. 256. My lords, it is a.
So more or less same ground.
Yes, my lords, more or less same ground, my lords, all matters.
This same order will do. Yes, what is your stand about interim prayer?
My lord, so far as the interim prayer, my lord, my only instruction is that since this entire case, there is a complainant, my lord, who have been make a party here, 2 and 3, my lord. So let notice be issued unless and because they will be contesting, my lord, this.
Whatever is your stand, forget about
My lord, so
complaint.
far in the other cases, we have not raised any objection, my lord, which they are
So
denied.
you are not having any
My
objection. That is, you say it directly. Why you are saying it?
No, my lord, in the present case, since none of the parties
you
have.
have to go by your instruction, isn't it? If you say that you have no objection, we'll say there is no objection. Okay. The first right in the main case. Mr. Pandey, notice 3 weeks. You will.
1, my lord.
What?
Only for 1.
1. And how many more are there?
2 more, my lord. They are all together 3.
MS Colony, G appears for 1. For remaining respondents, petitioner to take steps within 2 days. List after 3 weeks. Okay. And come to the miss case. Just say, where is the miss case here? Yes, miss case number 7 of 2025. Yes. Who are you? You are a contractor, or you are what? You are Mr. Pandey?
Contractor, my lords.
So more or
one of
less
the
you
matters.
are covered by the last order, isn't it?
Yes, my lords. Contractor is covered by the last order, and for my lords, the matter of Augustine Marak, which is the first petition your lordship has,
Yes.
there is that is also, my lords, similar. And in fact, in one of the cases of Augustine, my friend is carrying an order. There is also an interim order passed.
Who is Augustine? Augustine is a
The first case.
My lords,
what is his?
he is an office bearer of GHADC, office bearer of the GH. One of the matter is office bearer of GHADC, and the second matter, my lords, is of the contract.
Your Simon T. Sangma, isn't it?
Is a contractor, my lords.
No, but then come to paragraph 2, misapplication.
Your lordship is reading miscellaneous case number 7.
Yes.
It is submitted that the petitioner has been illegally and without any
No,
jurisdiction
petitioner who was
subjected.
deputy chief executive member GHDC.
That is, my lords, in the first matter
No,
of
that is
Augustine.
in the miss case 7. We are holding miss case 7. Show him. This paragraph 2. So miss case 7.
In my copy, it is submitted that the
You correct
petitioner.
it. We will go by court's copy. We will not go by your copy.
Yes,
cannot-
yes.
See, let it be corrected. We will have it.
We have skipped file of one copy. My copy is correct.
You correct it.
My lord.
We'll have it next week.
My lords.
Yes, just right. You check all the other petition also.
Yes, my lords. I'll get it checked, my lords.
First one you just say on prayer made on behalf of the petitioner. List after a week. The first writ petition. We see it. And then the second one, you just say It appears that there is some clerical error in the accompanying miscase number. This order will be passed in the main case. In the accompanying miscase number 7 of 2025. Learned counsel for the petitioner prays for grant of some time to verify and correct the same. Prayer order list after 1 week.
No lords. Obliged.
Item number 3. May it please, Your Lordship. Your
Yes.
Lordship, I humbly pray kindly this matter may be listed after 2 weeks, Your Lordship. Because the conducting counsel is having some personal difficulty.
Oh, that is that
Yes,
assistant
Your Lordship.
judge.
In the speak of the jurisdiction.
The assistant judge, Your Lordship.
Yes. We do not have any instruction with regard to
We
this.
have also communicated to them to
Clarify.
furnish any notification
Seeking clarification on this. Please, that's what I Okay, on the prayer. Yes, Mr. Pascal, we will have after 2 weeks.
Yes, Your Lordship.
Yes, prayer made by Ms. Honored Counsel for the petitioner. Just after 2 weeks.
Hello, Your
Yes.
Lordship.
Deeply obliged, Your Lordship.
Item number 5.
My Lord, I pray for some more time to file my objection, my Lord, today.
Yes. Prayer made by Mr. Samrat Dev, Honored Counsel, appearing for the respondent number. Appearing
Sole
for
respondent.
for the respondent.
Obliged.
2 weeks. Time is granted for filing.
Objection.
Objection.
Obliged.
Highly obliged.
Item number 6.
Your Lordship, I'm praying for 2 weeks' time to file the show cause, Your Lordship. 2 weeks' time
For?
to file the show cause, Your Lordship, in the miscase.
You are appearing for?
For the petitioner Abhiram Hajo.
So where is this there in the miscase? What is the miscase
In
about?
miscase, I'm for the respondent, Your Lordship.
Miscase is about what?
Such-
What is the
In the miscase,
Petition-
the petitioner, she's challenging the maintainability of this petition, Your Lordship.
okay in the miscase? Just say 15. Your name, please.
Deep Osnam, Your Lordship.
Yes, Miss so Lorna Council appearing for. the opposite party prays for and is granted. Prays for and is granted for the 2 weeks time for filing objection.
Your Lordship,
Yes.
I don't have an objection and required adjournment, but Your Lordship, it's a humble request to kindly start an appropriate interim payment.
No, if the
As
question
I'm-
of maintainability is there, then we have to decide it. You are not objecting to that. So after we decide about maintainability, then only we come to the other questions. Is a maintenance matter?
Yes, Your Lordship.
So why you are not paying maintenance?
We have paid this one-time alimony, Your Lordship, as per the
Your Lordship, the case has been enrolled on 21st April 2025. Since then, there is no interim helps after filing of the case, Your Lordship.
the petitioner and the
Since
respondent.
there is one-time settlement.
Yes, Your Lordship.
Is,
It has been paid.
It's a there is a separation deed of there's a deed of mutual separation, Your Lordship, and it's done before that, before filing domestic violation case.
Anyway, we'll see to it. What we
Your
are saying.
Lordship, me and my daughter, we are in a very trouble, and we need, since it's been so many months.
No, we can understand, but then in such a case, then argue the maintainable matter then. But then that objection is to come. You are not objecting to their prayer for grant of time. This we can hear you only after the objection is disposed of. Objection to the maintainability. Prayer is granted for the 2 weeks time for filing objection. List accordingly, and then in the main case. List along with Miss case number. So it's
Highly obliged, Your
Much
Lordship.
obliged.
Item number 7.
yes.
This notice has been complete, Your Lordship, but private respondent, we have served on the 19th, 9 2025, the order is also is reflected because we have completed all the service to the.
Anyone appearing for respondent 5 and 6? No one.
Nobody has appeared.
So what shall we do?
It can be posted for hearing, Lordship.
Yes, we'll do that then.
Yes, Lord, it can be posted for hearing.
Just say Mr. Petit Sangma, Learned Counsel is present by petitioner, and Mr. Kharmi, Learned Additional Senior G, appears for the state respondents. State respondents is respondent number 1 to 4.
Yes. 1 to 4, yes.
However, there is no appearance on behalf of the respondent number 5 and 6. Despite of service of notice. Next paragraph, as per with the parties, let's matter for hearing after 2 weeks. Yes.
Item number 8.
Much less, Lordship.
Well, this is that BSF matter, my lord. Where I've been convicted by the BSF Security Force Court and sentenced for 7 years. And as of today, I've served 4 years of my punishment. The primary argument is on the procedural aspect. I have 2 grounds of argument. One is,
Who is the other side? Dr. Mujika?
Lordship.
Yes. He's there?
Lordship.
first of all, my lord, the first argument is that, my lord, after the finding of sentence and pre-confirmation of the sentence, my lord, I am allowed to file an appeal, which is akin to a statutory appeal filed by a government servant before the concerned authority. That appeal was preferred. However, my lord, when the appeal was decided, it was not decided by the Director General, who is supposed to be the concerned authority, but it was decided by the Chief Law Officer. It was signed by the Chief Law Officer. And my lord, on that aspect, I have placed a judgment of our own High Court, my lord, Pradeep Kumar Hajong's case. A similar matter was decided. The Honorable Division Bench came to a finding that such an authority cannot be delegated to the Chief Law Officer. It was to be decided by the Director General. It was not decided by the Director General. So the writ petition was to that extent allowed, and the matter was relegated back in that particular case. The other aspect of the matter is, my lord, Rule 86 of the BSF Act, which mandates if a witness is dropped,
Yes.
then, my lord, I am given an opportunity to either cross-examine the witness or to bring that particular witness as my witness. Now, here, my lord, interestingly, of all the witnesses, prosecution witness number 8, my lord, who has spoken in my favor, to the extent that he has said, my lord, the allegation against me is that, my lord, I have committed an offence of rape against the another constable's wife. Now, prosecution witness number 8, my lord, what he says? What he says is that, my lord, he was aware that I was having an affair with the victim. And out of all the witnesses, my lord, he was the only witness who was dropped. And, my lord, if the witness was to be dropped, my lord, if you see Rule 86, I should have been given an opportunity to either cross-examine him or to bring him as a witness. That was not given to me. My lord, the border security force, my lord, they follow their own rules and regulations when it comes to...
In which manner the list of witnesses furnished before the...
initially, my lord, what happens is that, my lord, the BSF...
Just give us the steps, like what happens.
I will not.
After the incident.
Well, after, first of all, my lord, when an offence is committed, which can be tried by the BSF, they write to the concerned session judge, and the entire record is sent to the BSF. The BSF is allowed to conduct their own proceedings, provided the offence is committed within their premises or during duty hours.
It's okay. It was taken over. And
So taken over.
Now,
So
what is the
thereafter-
procedure followed thereafter?
My lord, thereafter what they do is, my lord, they prepare something called the record of evidence, ROE.
Okay. So where,
The difference-
where do we get it? Is those steps are prescribed where?
My lord, that is under the BSF Act and rules itself.
Yes, but just if you can take us to that, because this is this court is not well versed with these procedures.
Well, I'll take you to the procedure.
Now, taking over of the case at the stage of investigation and after charge sheet is filed.
After charge sheet is filed.
Now, is there any difference into that? In that?
Well, in this case, this is a case warranted by the allegation against me is of rape.
No, what the department it is? What the investigation, the inquiries with the department here, or department took over the matter for trial after charge sheet was filed?
It took over the matter for trial, but it also conducted its own investigation.
No, but then what about the investigation by the state police then?
Well, it will still be there, my lord, because the medical evidence and the other witnesses will have to come and depose.
No, but then was there any charge sheet there? Was there charge sheet filed in the
It was filed, my lord. The charge sheet was filed.
So it was taken over after the charge sheet was
After the charge sheet.
So it means that only the trial was claimed.
Trial was taken over by us,
Yes.
by the BSF.
Now, okay. Now, what happens when the trial is claimed by BSF and when it is handed over? Whether they proceed according to the charge sheet submitted by the state, or they take into consideration their own independent inquiry report.
They do their own inquiry, my lord.
But then
it is called the ROE. They prepare a ROE. The only difference is, my lord, when an ROE is prepared.
There is something, you see, I think
we have
it is provided in the BSF Act.
My lord.
See, the investigation by the state police, subsequent taking over of that by the department.
My lord.
After the charge sheet is filed. Now that is basically taken over only for the purpose of trial.
Yes, they want to conduct their own trial. They want to punish the.
So then what happens to the charge sheet?
My lord, the charge sheet, as far as, my lord, the investigation of the police is concerned, my lord, here medical evidence also plays a very important role. So, my lord, that medical evidence will be taken into consideration.
Talking about the procedures, we will come to all those things. Important to see importance of evidence.
But that, my lord, we have law officer over here. Perhaps, my lord, law officer can throw light.
Dr. Mojiga is there. Dr. Mojiga, please tell us what happens in such a situation. What happens to the status of the charge sheet? What happens? And
This is for me. May I submit?
Wait, let us.
My lord, there's a hearing on charge, my lord.
Rule 45.
In fact, offence report is submitted and is given.
What is offence report? Now, what happens to the charge sheet?
It's basically charge sheet.
This charge sheet. So, charge sheet becomes offence report.
My lord.
Now, where do we get all those things? Is it provided in the Act or rule?
This is in the rules, my lord.
Yes, where is that in the rule? After taking over?
Rule 40.
Yes, we'll allow your law officer to say. I think he may be well versed. If you do not have any problem with that,
yeah, I have no problem.
Yes, just tell us kindly, Mr. Officer. Yes.
My lord, after taking over the case from the court for trial purpose, the hearing is conducted under Rule 45 of BSF rules.
Rule 45. Now
44 also, my lord. Charge sheet is Rule 44. Then there is a hearing under Rule 45, my lord.
But then, my lord, that
now
charge
then
sheet.
what do you know? Because since the issue has been raised with regard to the witness also. Now if a matter is investigated by the state police, charge sheet is filed, the charge sheet will naturally contain a list of witnesses, isn't it? Now, with whether dropping any witnesses from there, that also requires the compliance of Rule 86 or not. That also is a question. Now, Rule 44, charge sheet.
45, my lord.
44 charge.
And the charge are mentioned in the office report as per Rule 43 in case of other than officers.
What Lordship's query is what happens to the charge sheet.
Exactly, that is
That is disregarded.
What is the status of this? You see,
Yes, my lord.
what happens to the charge sheet?
My lord,
Because charge sheet is prepared as per procedure of the CRPC or the BNSS, whatever the thing.
yes, my lord. After
But then, so far as BSF Act is concerned, now if you see Rule 44, it speaks of Appendix 6. It shall be
Appendix 4 in this case also, my lord. Appendix 4.
Rule 44 come to these things. When it is alleged
Rule
that
43.
Rule 43. Where is alleged? Okay. He's
All
an
the
officer.
charges are mentioned in the offence report.
He's an officer. Oh, he's not an officer.
Yes, my lord.
Okay. In the form set out in Appendix 4. Now what happens?
My lord, after the hearing.
Wait. First we are trying to understand about the Appendix 4. Now the charge sheet takes the form of Appendix 4.
Yes, my lord. Yes, my lord.
Where
all the charges are mentioned in the form of this.
Let us see where is Appendix 4. Let us see what is the format of Appendix 4. Mr. Gautam, have you checked Appendix 4?
My Lord, page 1110, I think we are using the same book.
Is it perimeter with the charge sheet, the form of charge sheet under CRPC?
No, my Lord, the former charge sheet will be disregarded.
It will be disregarded.
Because, my Lord, that is filed under 173 of the CRPC. They take over investigation, they prepare their ROE, and thereafter the charge is framed in a one-page.
Now we need clarification on that aspect.
I think, my Lord, that as far as that is concerned, my Lord, if I am to show any discrepancy between the investigation of the police and the investigation done by the BSF, my Lord, I will not be allowed to do so because the charge sheet filed by the police will be disregarded.
Where do we get it? It will be disregarded.
Well, that
and then what becomes the basis of this Appendix 4 then?
Well, they conduct their own investigation.
If you say the charge sheet filed by the police is to be disregarded, then the investigation by the police goes.
Well, in fact, even the medical evidence
then
should
their
go.
case has to be established on the sole basis of their inquiry.
Yes, my Lord.
Now, if it is to be, you see, like made the basis for a trial against you, then Appendix 4 comes into play.
Yes.
Now, then what is the basis of Appendix 4 then in this case here?
Well, my submission is they will prepare the ROE in terms of 48, and thereafter, my Lord, they will frame charge. But in my particular case,
48 means Rule 48.
Rule 48.
Now, Rule 48 applies to matter where this investigation is conducted by police also.
Yeah. My lords, after conducting hearing under Rule 45, 48 is conducted. Record of evidence is prepared under Rule 48.
Look, that charge sheet prepared by them will not be the charge sheet prepared by the police. Well, it's just like the charges, just like explaining what charges are there against you.
Now, offence report is what? Offence report is something like a FIR.
Charge sheet.
Then 43 comes, Rule 43. Then what is the question of...
Only my lord, format is different. For other ranks...
offence report is charge sheet. Now, if you say offence report is charge sheet, now it says that it should be in the form of Appendix 4. Now, you submit it. And then at what stage 48 comes then?
My lord, after concluding the hearing, the commandant remands the accused for preparation of ROE, record of evidence. Rule 45, sub rule 2, 3.
No, that is 45 comes, that is something like trial, isn't it? It is not an investigation.
Hearing of the charge, preliminary hearing, my lord.
He's just explained that you've been such and such offence, and thereafter, my lord, it is heard, and thereafter they do the ROE. It's
No,
their
that is something like
like
framing of
filing a
charges.
show cause in a departmental proceedings, my lord, kind of a thing.
We do not understand. The court is not yet clear on that aspect. Now, if 43, the offence report is equivalent to charge sheet, and after it is submitted in the format of Appendix 4, then comes 45. Then hearing of the charge against an enrolled person. And then it prescribes for examination of witnesses. Now, is it not connected with the inquiry? Is it something akin of recording evidence of a witness in a criminal trial? Do you cross-examine this thing?
Yes,
a witness at this stage?
In the ROE also we are allowed to cross-examine.
And then thereafter a record of evidence is prepared.
Yes.
Okay. Rule 48. Now then what happens? After record of evidence?
Rule 49. 59.
Abstract of-
My lord, Rule 59.
Yes.
The case is submitted to the authority, sir. After 48, compliance of after compliance of Rule 48, the commandant examines the matter under Rule 51.
Then from what stage this court of inquiry starts then? We have
And
something not
after examination of matter under Rule 51.
Wait. See, Mr. Officer, you understand everything, you see. We do not understand. You have to make us understand, then you have to proceed. If you proceed without making the court understand, court will not understand. Court will. No, 45 and 48 applies to the same stage, isn't it? It is not that these two rules apply to a different stage. "45 lays down the manner how the charge shall be heard by commandant. Which authority has held you guilty?
My lord,
Now the trial,
my lord.
is by security force court, isn't it?
Yes, my lord.
Now security force court is not commandant, isn't it? Commandant is somebody different.
Yes.
Yes, my lord. Commandant is.
Now that is where the difficulty is. So it means, see, unlike a criminal case, where trial begins after submission of the charge sheet, here it is not that. Even after offence report is submitted, then commandant again he records evidence, as per in terms of Rule 45. Subclause 3, what has been pointed out by the officer here. Isn't it?
Always the commandant, my lord, and officer.
Whenever witnesses are called by the commandant, the accused shall be given opportunity to cross-examine them. Meaning thereby, isn't it? Now so it means even after filing of the charge sheet, there is examination of witnesses.
My lord, initially, my lord, what 43 meant here is, my lord, offence report allegations is read out. And, my lord, thereafter, my lord, the question of recording of evidence comes, the preparation of ROE comes. And when ROE is prepared, my lord, I am allowed to cross-examine. The accused is allowed to cross-examine.
See, at the stage of ROE, when this ROE is prepared, that is what the Rule 48 says.
My lord.
Isn't it? You should be given a chance to cross-examine.
To cross-examine.
Now, after that is completed, what becomes? Is it becomes after this? Do you go for a hearing directly?
Again, Lordship, it is placed before the commandant.
Yes.
For him to satisfy whether to proceed with the charge or to discharge.
So definitely, okay.
Then it
Similar
comes
to that.
giving of charge, and then again the same witnesses are again examined.
So that force court has to take evidence again. So
Again,
that means
twice.
that is the two things. It is the process. So process is akin to a CR case, not a GR.
In a CR case, exactly like
that is
CR
what-
case. I should have said that. In a CR case, when you are initially allowed to cross-examine.
By saying so.
I was confused because, my lord, what Lordship wanted to ask is what happens after the evidence is
No, but
recorded.
then here the thing is that here it's just investigation. A charge sheet is there by state police. Now that is ignored then.
My lord, that is
So
disregarded.
that becomes irrelevant when trial is taken over.
Yes, yes.
Is it correct?
Yes.
My lord, on the basis of that charge sheet submitted by the police, all the evidence related to the whose statement recorded during the police investigation, and other witness may also be examined during the record of
That's
evidence
all right.
48.
See, that is so far as the.
But it is only the matter is taking over from the court.
So it's a kind
under,
of aid for
under
you, you
section
see.
80.
It's basically serve as an aid to you, isn't it?
Yes, Your Honor.
For preparing record of evidence.
Yes, ma'am.
Isn't it? So that way a charge sheet loses its identity as a document, you see, like a report of this. Once a matter is tried,
Because your Lordship sees the
By-
charge, because charges are framed now onto the BSF Act, not on the IPC.
I have not tried under section 376.
Charge.
now here the charges were framed under what section?
46 of BSF Act.
First is section 46 of BSF Act,
46 is civil offence.
Read with 376.
read with section 376 IPC.
Now again, now the penal offences, BSF court has the power to try offences under the penal code.
My lord, all the civil offences are tried under Section 46 of BSF Act.
Civil offences.
Yes, my lord. Which are not
By
provided in the
saying civil
BSF Act
offences,
itself.
what do you mean by civil offences?
Other than the offences which are mentioned in the BSF Act only.
So even the criminal acts which are which falls under IPC, not under BSF Act,
They are all called
these
civil.
are all civil offences.
Yes, my lord.
So this is a case 376 is a civil offence.
Yes, my lord. Under Section 46 we try.
Okay.
Offences under BSF Act.
14 onwards. Section 14 onwards. So, offensive BSF.
Well, just to get some idea, my lord, what are the offences under the BSF Act? If Lordship kindly sees section 14, 15 and 16, my lord. Because what happens, my lord, in armed forces, even disobeying the command, deserting the command, those are the main offences listed under the BSF Act, which otherwise are not offences under IPC or any other.
It's normal criminal acts are normally under IPC, yes, or the BNS, whatever it is. Okay.
14, abandons or delivers of a post, intentionally uses any means to compel or induce any person subject to this act or military so and so. So these are internal offences, my lord.
Up to 46. 46. Up to 46.
This, whether this civil definition of civil offence is provided in the Act?
46. Definition section 2.
D, 2D, my lord. Civil offence means an offence which is triable by a criminal court.
Yes. Okay. Now, at what stage, it's all right now, let us probably, whenever the confusion comes, you will stand up and you will clarify it. Let him proceed. Now, tell us at what stage this list of witnesses are provided.
When the, my lord, ROA is prepared,
yes,
those witnesses are the witnesses which are supposed to be called. So those are the witnesses, my lord.
The persons, those who are examined at the stage of preparation of ROE,
yes,
they are the. Now, is there any provisions of providing specific list of witnesses? It may happen like that after ROE, the prosecution may not want.
So that is where, my lord, Rule 86 will come into play. So suppose if they don't want to call any witnesses, if they want to call additional also, my lord, the provision is there. But if they want to drop,
there is no formal submission of a list of witness. It is only those who comes during the course of preparation of ROE. Is it?
But if somebody additional has to come also, my lord, provision is there. I'll just.
No, what about this? Is there anything, any specific provision which says that yes, the prosecution should submit a list of witnesses?
No, it's the ROE.
Before the ROE starts.
No, my lord, I'm not aware of that. Because, my lord, it's on the basis of the charge sheet, when the ROE is prepared, on the basis of the charge sheet, my lord, they call the witnesses and then they examine the witnesses. Of course, they can call other witnesses also. Even at the time of the trial also, they can call other witnesses, my lord. But if they have to drop a witness, then, my lord, my case is that, my lord, they dropped a particular witness which was deposing in my favor. And if they were to drop the witness, my lord, they should have given me an opportunity to either cross-examine the witness or to call that witness as a defense witness. That was not.
That is what the 86 says.
And 85 talks about additional witnesses. If they want to bring additional witnesses, prosecution can bring additional witnesses.
Additional witness means like a person who has not been examined during the preparation
During
of ROE.
So, well, this is vital because, well,
something akin to 311.
311, well, similar to 311. So, my lord, by not giving me this opportunity, my lord, I have not been given a fair trial.
Let us see what this 86 says. Just can you read it out?
Dropping witnesses, the prosecution shall not be bound to call all the witnesses against the accused whose evidence is contained in the record or abstract of evidence, nor a witness when he has notified the accused that he intends to call under Rule 85. But if the prosecutor does not intend to call such witness to give evidence, he shall either tender him for cross-examination by the accused or give the accused reasonable notice that he does not intend to call the witness and that the accused will be allowed to communicate with him and to call him as a witness for the defense if he so desires, if the witness is available.
Okay. Now here PW8
My lord.
was not examined. He was dropped.
Dropped.
Now, is there any difference between not examined and dropped? No.
My lord, if you are not examined, my lord, automatically you are dropped.
See, dropping at the instance of the prosecution,
My lord,
dropping
why, my
at the
lord?
instance of the court may be two
My lord,
different things.
why am I stressing on this, my lord? If he was a normal witness, if he was a normal witness, my lord, if he was not examined, I would say he was not examined. The reason why I say he is dropped is because, my lord, he was dropped because he deposed in my favor. Had he been a normal witness who had given any other evidence, my lord, then if it was not examined, I would have said not examined.
So that means you want to say that the prosecution is duty bound to examine all the witnesses.
Not duty bound. Not duty bound.
Then if they do not examine, then it will come to dropping them.
If they do not examine,
unless there is a specific prayer for dropping, they are duty bound.
they are duty bound. If they do that. But the reason why I'm stressing on, I'm saying the difference between not examining and dropping. I would not have any quarrel if they have dropped any other witness. But the fact that of all the witnesses they choose to drop a particular witness who's speaking in my favor, that is where the quarrel lies. So by doing so, my lord, what has happened is that I have not been given a fair trial. These two aspects of argument on the procedure.
Yes.
Now, if we have to go through the evidence, also, my lord. If you have to go through the evidence also, my lord, this is a case otherwise under 376, tried as a civil offence under 46 of the BSF Act. The finding is on the basis of the sole testimony, mostly on the basis of sole testimony of the victim. Now, my lord, when there is a particular witness who says,
What is the accusation against you?
that my lord, I have committed an offence of rape.
Where is that? Just show us. Please take us to the things.
My lord, I'll take lordship to the evidence. Well, I'm just reading.
To Barbell. You see, like just take us, draw us.
I'm
to
just,
our-
my lord, just a gist of what is the allegation. But then I'll take lordship to the entire argument. So, my lord, the allegation against me is that, my lord, I have committed an offence of 376 against another constable's wife. Now, my lord, during the examination of all the witnesses, my lord, and after the trial, let's say the trial, when the actual evidence was recorded before the BSF court, the only weightage which in this particular case can be given to is the evidence of the victim, or otherwise, let's say the medical.
How many witnesses were examined at the stage of record of evidence?
Well, altogether, we examined around.
So, officer, you please sit down. You sit down, take the record with you, sit down. Do not stand up. You see, otherwise you will draw attention.
15 witnesses, my lord. 15, I see 15 witnesses. So, well, of all these witnesses, well, what I am saying, well, what my case is, the most important witness is the victim. Now, here, my lord, there is also a delay in filing the FIR. What has happened is, my lord, after the version of the complainant, who is the husband of the victim, is that when he came to learn about this, he first went to the authorities and he first wanted that the writ petitioner be punished. He be thrown out of service. When no such thing happened, thereafter he went ahead and he filed an FIR. There is a delay of, let's say, 2 days.
How do you, on what basis you say he first?
Well, I'll read out the evidence. I'll read out all the evidence. Well, I'll read out all the evidence. I'll point out also.
So that is in the.
It's on record. It's on record. So basically, my lord, my case is that, my lord, In fact, my lord, lordship will also see there are certain messages which have also been exhibited from the mobile phone, which was used by the victim. And my lord, I have texted the victim, and the victim has said, "आप आ जाओ, वो 4 बजे जाएंगे, आप 3 बजे आ जाओ, whatever is there." I'll point that out.
Do we exercise the jurisdiction of an appellate court?
Well, I'll place some judgments.
Where section 386 will come into play that we have to go through.
My lord, I'll place some judgments of the Supreme Court in this regard. So, my lord, the court
What
says
does
that
it
we
say?
can.
Just tell us the principle. Why you?
No, my lord, the principle is such, my lord. If the court, the High Court,
place decisions, that is welcome. That is okay. But then just tell us what is the principle.
Ordinarily, my lord, the principle, my lord, in a criminal writ petition of this nature is, my lord, lordship will not directly go into evidence. Lordship will see what is the, if there is any procedural lapse, lordship will there and then close it.
So akin something like you see like exercise of a revisional jurisdiction, not an appellate jurisdiction.
But my lord, if I am able to satisfy, that there is no evidence, well, the entire judgment is perverse, then lordship can go through the entire evidence.
That is what the revisional jurisdiction is about.
My lord, lordship. But
you see, we see it is unlike an appellate court. It takes into consideration the entire, appreciates the entire evidence.
Yes.
And says what could have been taken.
Yes.
Or what not.
Yes.
You see.
Yes.
Whether there is a possibility of two views or not.
My lord.
But in the revisional court, we do not do that.
Yes.
We see whether finding is based on materials on record or not, or whether there is a perversity. 2 plus 2 it is 4, they say it is 5.
Yes.
That is perverse. So if you can establish something sort of this, so our jurisdiction is that. Our limit of our jurisdiction is that. Yes, thank you. Please, now you can proceed.
So, my lord, the complainant initially, what is my case? My lord, my case is, my lord, morally I may have been wrong. I was having an affair with somebody else's wife. I am a married man. I was caught. They were caught. Obviously, the husband wanted to go and complain. He wanted the person to be chucked out. But did not happen. Thereafter, after a couple of days, he filed an FIR. In the FIR, the allegation was made that such and such thing was. Now, when we go through the evidence of the victim calls me. She does not know me by name. Certain places she says, I don't know this person by name. In certain places, she refers to me by name. In certain places, it is said that the victim has a speaking difficulty. She cannot speak properly. But her evidence is recorded. She has given her evidence herself. So, my lord, whether that kind of evidence, in fact, when the entire case rests on the sole testimony, whether the court could have taken, or the BSF court could have taken into consideration or not. So, my argument before this honourable court is twofold. First of all, my lord, I say there has been procedural lapses.
Did you examine the victim? Cross-examine the victim?
Yes.
Now, you had any difficulty in conducting cross-examination?
No, my lord. Why I am saying
that she is not in.
No. The reason why I am saying that is because, my lord, initially she said that, my lord, she is not able to speak. Some witnesses have said that there was a difficulty for her to speak because she cannot speak well. But when the examination was done, she spoke very fluently.
You are basically pointing out to her conduct.
To her conduct, my lord, and the flaws in the entire recording of the evidence also. So, my lord, my argument at the end of the day becomes twofold. First of all, procedural lapses, two very, very stark procedural lapses. Number one is signing of my the appeal by a law officer. And number two is dropping of a very, very vital witness who could have turned the entire course of the case. Apart from that, the evidence. Now, my lord, before I read out the evidence, my lord, I'll only ask one thing, my lord. If from my learned senior can say that, my lord, the procedure has been followed or not. If he can satisfy that, my lord, the law officer signing is okay, dropping of the witness is okay, then I will place.
Record was called for. We paid the record, and a copy of the order has been supplied to us. No, they have. That is their contention. Is this only communication is by law officer?
So, my lord,
otherwise it is an order by DT.
Well, would it suffice, my lord? The question is, would it suffice? Because
we'll decide.
Because, my lord, if that is an order which is to be passed by a particular authority, which cannot be delegated, and I have a judgment of the division bench, my lord, also was gone.
Where is that order? Where is that order? Just show us.
My lord, that judgment.
Yes.
Well, I placed it on the last occasion.
Oh, it is not a part of the paper book in your compilation.
It's already there, my lord. I think it's there, but
no, it is not. Is it in the compilation? If it is there, then you tell us what is the page number.
But I'll give you one more copy. It's just
no, that is okay. No, we have probably.
Well, I'll read para 3 onwards.
This is note sheet 20, isn't it?
Yes, my lord. So, my lord, in this judgment, my lord, if I may read out from para 3. This is judgment of the division bench.
You are reading out para 3 for what?
Well, I am reading Pradeep Kumar Hajong's judgment.
No. You are right now. Your submission is that this order,
My lord.
impeachment order, was not signed by the DG.
Yes, my lord. It was not
Isn't
signed. It was signed by the chief law
We are
officer.
not asking about the citations which you are relying on. We are talking about the
Lordship.
order which is under challenge here.
My lord.
Now, one of the pleas raised by you that non-compliance of section 117 subclause 2.
Subclause 2.
That means this order has not been signed by the competent authority.
Yes.
Instead, it is signed by some law officer.
Somebody else who is not
Now,
competent.
if you succeed in that, then the entire case,
Absolutely, my lord.
case, entire
Absolutely.
conviction goes. Now, this to ascertain that a record was called for.
My lord.
We peruse the thing. And
I
a copy of the order also has been supplied.
It's not been supplied to me, my lord. But I have perused it. I still remember.
You have not been supplied with a copy of this order.
No, I have not been supplied. The one that from the record I was not supplied. But I have gone through, my lord. They have some
No,
resolutions.
but then there appears to be signature of the DGP there.
But my lord,
Well,
that is the internal
order
thing, my
sheet.
lord. That is the internal thing, my lord. That could have been signed any time. What I am saying is that, my lord, what was supplied to me.
This is very difficult to establish. See, can you know to what limit we can go with?
My lord, that is what I am saying, my lord. The one that is supplied to me is the order.
See, without a copy of the order, how you have preferred this?
No, my lord, that is not the order. The copy of the order is there in the writ petition. The one that has been the one that has been supplied to me.
Supplied to you. So point out to that one.
Well, the one that is the what has been.
So that means the copy. Are you taking a plea that the order,
my lord,
which is wait, just a minute.
Lordship.
Have patience.
My lord, I'm sorry.
See, we must communicate clearly, otherwise,
My
you see,
lord.
there will be no process.
Lordship.
Is it your contention
My
that
lord.
the copy of the order, which is there in the record,
My lord.
is not the copy which was supplied to you?
I could not have taken the contention then, my lord, because I was not aware of what is there, my lord. This was produced during the proceedings.
But then after you've seen the record, now what will be your condition?
My contention is that, my lord, I can only say page 99 of my writ petition, my lord.
No. Are you saying that this is not the same copy?
Well, if it was the same copy, my lord, the same copy should have been supplied to me.
Tell us what is your contention. We'll go by your contention.
My lord,
it is not that you should go at the suggestion of the court.
Well,
you
what
just say whether it is a copy of the same order or not. That is the main thing.
my lord, that is the note sheet. This is the order which has been supplied to me.
So that is not the order.
No, my lord, it cannot be, my lord.
Have you checked the contents and all?
My lord, the contents may be the same, my lord, but the fact remains, my lord, if it was that, my lord, it was signed by the officer, if the officer was present.
What is your page? What is you said? If your order is at page 99.
Page 99, my lord. The last page.
You should prepare a written note.
Well, I'll prepare, my lord. I'll prepare a written note also, my lord. This is just two contentions I have taken, my lord, regarding the procedure, which is
just a minute. Now, normally,
my lord,
in this kind of inquiry by the security force, when this order of conviction is passed,
my lord,
the copy of the order is not supplied to you. The copy which is there in the record, that is not supplied to you. Is it that they prepare some extract copy and then different, which is something different from the which they retain, that is supplied to you? See, any procedure laid down in the rule which speaks about supply of copies.
well, that note sheet is not supplied. It's the internal thing, my lord. That is not
How
supplied.
can order be internal? This is an order.
That is what I am saying, my lord. What has been brought before this court is the internal note sheet, whatever is there, well, they have done in the department. What is important is the one which has been supplied to me, my lord. Because I filed an appeal, it was sent to me by post, my lord. It was my petition was not considered, it was dismissed.
Page 99, isn't it?
Page 99. Lordship will see page 99.
There is no requirement of, you see, like furnishing a copy in case of conviction.
Right, my lord, that is there, my lord. But that is the order of conviction. This is after the conviction.
That is no. Where it is provided the copy of the order is applied to you. What is this? This is the order. Page 99.
Page 99, my lord, is the order of post confirmation, my lord.
These are not very legible. Where is the order which you are talking about? What is the order which you are saying that it is not sub?
It is. It starts from page 88.
Page 88.
Page 88. This is the disposal of my statutory petition, my lord.
The disposal of your statutory? Page 88 is what?
My lord, this is disposal of my post confirmation application. Appeal, basically.
This is post confirmation. Now, just tell us what is the procedure. How, after you are held guilty, then what happens? Just tell us about it.
Thereafter, I am taken into custody, my lord.
No, once you were
First,
pronounced.
it is pre-confirmed, my lord. Pre-confirmation is there, my lord, which you lordship will find.
You are say once you are convicted.
My lord.
Then what is done by the security force court? What they do? Do they pronounce the order of conviction?
Yes, my lord. Then I am taken into custody.
Are you there in the case, Mr. Dev? We will appreciate your service definitely, but then probably.
He's arguing the Pradeep matter, my lord. So.
No, that is, he may have some expertise and we definitely would. But then you may not have a right to say. You can definitely guide citizens.
My lord, pre-confirmation is there. Pre-confirmation is done there and then, my lord. Pre-confirmation has been done in page 87.
Pre-confirmation, at what stage pre-confirmation comes? And who does the pre-confirmation? Whose this business is? See,
by ADG, my lord.
ADG is not this thing. Now, after the security force concludes trial, what they do?
They either find me guilty, they let me go, or
Okay,
they call.
so once if they find guilty,
my lord.
Then who pronounces they pronounce the sentence?
My lord, the court does, my lord.
At what stage?
After hearing the entire arguments.
Now then, where is the question of pre-confirmation and post-confirmation?
Well, it's provided under the rules, my lord.
Now, who confirms the order of the court?
My lord,
and how pre-confirmation comes? It means
it is provided under the rules, my lord. Under one.
This rule must have there is some logic in the rule. Only it matters whether we are understanding it properly or not.
If you go through the entire BSF rules, well, I don't find any logic myself, my lord.
See, that has to be proper understanding.
But the fact is that, my lord, I have been tried by these rules. And I am bound by these rules as of now.
Please take us to those provisions where after what happens when this security court finds you guilty. Where is that?
Rule 99, my lord. Lordship, I think we're on the same book, page 84.
Rule 99.
And thereafter, my lord.
Just a minute, let us just go through the rules, just see. Now it says about signing of a presiding officer and the law officer in Rule 99.
That is only for 99.
But then where is the provision of sentence?
10-100, my lord, if I am acquitted. 101 if I am convicted.
Okay. Now, what he says, take evidence here, if you see,
My lord.
just read out that 101,
Yes, my lord.
subclause 1.
Proceeded on conviction if the finding of on any on any charge is guilty, then for the guidance of the court in determining its sentence and of the confirming authority in considering the sentence, the court before deliberating on the sentence shall whenever possible take evidence of and record the general character, each service
No,
rank.
but then what is that? What is meant by take your evidence of?
What is that evidence? I am not aware of that, my lord. 101.
Rule section.
101. Before sentence. Before sentencing.
It means it's something like taking notice of, probably, not evidence of.
Probably trying to know the antecedents of the accused person, my lord.
That is
Something
what
akin to
that is what. If
313.
you read subsequently, proceed to read subsequently, that is what it means.
It's like argument on sentence.
Now, see the again subclause 2, just see.
Evidence on the above matters may be given by a witness verifying a statement which consists of summary of the entries in the service books respecting the accused, identifying the accused.
So that means this evidence is taken after conviction is recorded.
Yes, my lord. If so required, my lord.
No, it is not. So this is a must because they will have to take into consideration the antecedent of the person. So that means subclause 2,
my lord,
comes into operation
after conviction.
Yes.
Before sentencing. After.
So has it been done in your case? Okay.
That, my lord,
See, this entire thing appears to be very, very confusing.
But the entire act
court.
seems to be very confusing.
Even this provision concerning awarding sentence is finding for the guidance of the court in determining the sentence and okay. Now, for guiding the court, the evidence has to be taken about the antecedents, and then subclause 2 says evidence may by a witness verifying the statement.
My lord.
Dr. Mojiga, you have to explain those things. This becomes quite confusing.
101 subsection 2, subrule 2.
Yes, subrule 2, subrule 1 also. And who is the confirming authority in considering the sentence?
In this case was ADG, my lord.
On what basis you decide who will be in which case? Where it is provided?
Quantum of punishment.
Rule 106, my lord, is the confirmation and promulgation.
Now, composition of security force code is more than one person, isn't it?
5 officers, my lord.
5 officers.
5.
And confirmation is by how many officers?
Only authority, my lord. Additional DG.
Additional DG is confirmed. It's the second next to DG in BSF.
This confirmation, does it create a layer of protection to the accused? So it means the confirmation can be denied also.
Section 107, my lord, of the Act.
Now, the force code consists of 5 personnel, and that is confirmed by one individual.
What is higher in rank?
The force code is not meant by the junior officers.
My lord, these are quasi-judicial, they are not judges. My lord.
Well, then is it not that you are dealing with the life and liberty of a person? When specially you have the authority to convict sentence somebody. Now, say supposing, what happens if that confirming authority disagrees with the sentence? That is also provided there. You kindly, Dr. Mojiga, please be well versed with that and then place it before the court. The court would not like to, hear it from your officers. Once you are there, you should address it.
I'll do that.
Because your officer's manner of explanation may be something different.
I understand. Because the procedure is quite different.
No, but then this court still has what requires this court strongly feels when we exercise the power of judicial review and writ petitions concerning the liberty of a person, we must be sure that the protection which the person is entitled to, that has been provided to him. The purpose of query is that. Now sentencing, it appears that now a security force court, when it records conviction, does it pronounce sentence then and there?
It pronounces, my lord, then the entire records are sent for confirmation. My lord.
So there is no separate system of hearing on sentence.
My lord,
Then where
101 will probably...
Then subclause 2, that 101, when it comes into operation.
Before sentencing. My lord, my lord, finding of guilty once, my lord, that you are found guilty of charge number this, then this steps comes, my lord, before pronouncing the sentence, to see his antecedents in the service book, my lord. They are pre-sentencing exercise.
So that means basically this is for the purpose of considering mitigating and aggravating.
Clause 4, my lord, if lordship will see clause 4, 101. When all the evidence of the above matters has been given, the accused may address the court thereon in mitigation of punishment.
Okay.
Just like, my lord...
so that means after the conviction also, evidence is recorded.
May be recorded.
Now, may be given. That is definitely may be given. May not be shared.
Only for lordship study.
For the purpose of the awarding quantum of sentence.
Well, here, why all these are provided, my lord? Because under CRPC there are appeal or revision. Because under BSA factor there no, so only say layer of safety is a confirmation, my lord.
No, but then see, even for sentencing,
My lord.
even a witness is called. Who calls the witness? And which witness is called? And whether that witness can be subject to cross-examination. It may happen like that. You see, like in a department, there are 2 officers. One officer may come and speak good thing about it. Another officer may not. Sentencing also is a vital part.
Yes.
Any law regulating those areas holding field.
In fact, I was going through, my lord, in 226, there are several decisions from Guwahati High Court, my lord, I have gone through. Very comprehensive judgment. They said, what are the parameters of 226? And court will only see perversity, my lord, will not go beyond that.
Now, how do we decide perversity? Without knowing law, can we decide?
Yes.
We must know law first to say whether something is perverse or not.
And these issues were no the judgments whichever are available.
We do not know. These questions are coming to the mind of this court.
Yes.
Now, if at all you have to decide on the question of prejudice to the accused, we may have to enter into those areas. Now, sentencing also has to be, anyway, if here, of course, Mr. Gautam's case is not on that, we may not go into it, these things, but then court must understand the procedure in order to appreciate the. Anyway, your contention is so far as your legal plea is concerned.
2 aspects.
See, 2 aspects, section, the violation of section 117(2) and rule 286.
Rule 86.
Now, what is the consequence of non-adherence to rule 86?
Well, specifically for rule 86.
Any decision?
I don't have any decision exactly on rule 86.
Except for what you have given us, our High Court's decision,
my lord,
where it was remanded back again.
That was for, my lord, 1172.
117.
It was remanded back because it was.
What about 86?
For 86, I don't have a specific case law, my lord. But what is my lord? I'll place some case laws where, my lord, if there is any deviation from the law, Because, my lord, what learned senior also pointed out, there are different layers because obviously, my lord, the scope of judicial review is very limited. So if they have not followed their own rules, my lord, it is a violation of Article 21.
But then 86 guarantees,
Which means
86 gives you a protection.
it gives me a protection which was, my lord, which I was not given, my lord.
It is not that they are supposed to move one-sided. They have to take into consideration evidence of
Absolutely,
all the
my lord.
witnesses.
Absolutely. So because this particular witness,
Just because somebody's witness is helpful to you,
yes,
they cannot evaluate.
they cannot
And
arbitrarily
probably
drop.
that is why this rule has come.
Yes, my lord.
That even if you drop him, then you will have the chance
Yes,
to call him.
then that witness can be called because I mean some witnesses may definitely speak in my favor, my lord.
So until and unless they are officially dropped, how you will know that he will be examined?
Yes, my lord.
But then, in a security force code, do you have the opportunity of adducing defense witness?
We have, my lord. We have.
Now, after their evidence was closed, did you ever make any attempt to call the same witness? Because by that time you know that he was not examined.
No, my lord.
Did you make?
But my lord, 86 talks about a notice be given to us, my lord. That notice was not given to us.
No, but then once they close it, that means it is over.
But it is a mandatory provision, my lord. 86 is a mandatory provision.
We understand that. But
Because
then we would also like to know that whether you have basically tried.
No, my lord.
to
No
call
endeavor.
him.
No endeavor was made.
Because if you say that somebody's evidence was vital for your defense, then it becomes your duty. You have to show us something that non-compliance of 86.
My lord, if, my lord, of course I should have been diligent, my lord, but I am only a constable. But I was defended by some other officer. If, my lord, there has been any promise and no endeavor was made, the fact remains that, my lord, this particular witness, lordship, as I have read the evidence of the witness also, it is very clear, my lord, the witness speaks in my favor. And morally, I may be wrong, my lord. Of course, the allegation is, my lord, allegation is of rape.
No, morality has nothing to do
Exactly,
with
my
criminal
lord. That is what I am
proceeding,
trying to point out.
There cannot be can there be moral conviction?
No, my lord, there cannot be. That is what I am trying to point out. My lord, I have been prejudiced in the trial itself. My lord, the force has purposely dropped this particular witness because the witness would have probably changed the course of the case. So by these two, my lord, discrepancies in the trial, my lord, of course, my lord, the judgments which I will place, my lord. So it's an infringement of Article 21 of the Constitution. I was not given a fair trial. I should have been given a fair trial. Before I go into the evidence, my lord, of course, if I read the evidence is a totally different thing altogether. There is no evidence at all. There is no evidence of rape at all. That is my case. And, my lord, one judgment, my lord, of the Guwahati High Court. My lord,
You have to take us to the evidence then to say that there is no evidence.
Well, I'll take
before you come to judgment you will give it at the time of conclusion of your case.
Only on the aspect of, my lord, non-adherence to the procedure. I was trying to place some judgment.
Okay, please give us that. What are your procedure is 1172 and 86.
My lord, 86.
There is an affidavit in opposition filed by the union.
They have filed one. We file a rejoinder to the affidavit.
This is Delhi High Court.
My lord. This para 35, one small paragraph.
You have raised those pleas in your writ petition.
I
those
have
86.
raised them.
And they have made given replies. They have responded to it.
They have responded.
Yes. Para 35.
35. It is tried so far as the procedure for disciplinary action, trials, and punishment in respect to personnel of the armed forces, paramilitary forces, and security forces is concerned. The provision of the various special statutes enacted for the purpose is fair procedure within the meaning of the expression for the purpose of ensuring the constitutional guarantee, deprivation of livelihood, and essential convenement of the right of to life by the way of any proceedings has to be by a procedure which is fair, just and reasonable. In view of the principles laid down in the aforementioned judicial pronouncement, strict compliance with the statutory prescription, rules and regulations in this behalf, as well as with the principle of national justice to the extent stability, therefore is essential. So, my lord, they are bound by certain their own statutes, my lord, and my lord, they have to be fair in their dealings. In my particular case, they have not been fair. They have not been fair, my lord. I was prejudiced from the very beginning, and my lord, which has led to my conviction. And not only my conviction, my lord, I have also been dismissed from service, which has given me the most, almost like a capital punishment.
Yes, so far as the procedural aspect is concerned.
Procedural aspect is concerned.
Yes.
Well, and if you have to go through evidence,
No, it's up to you whether you go or not. See, like, if you want to say that there is no evidence, then you have to show us that there is no evidence. If you want to show that there is a perversity, then you have to establish there is a
no,
perversity.
but what I am saying is, my lord, even my lord, by at
You
this
would,
stage,
you,
my lord,
you would not like to argue on those aspects by referring to the evidence and going to the finding recorded in the judgment.
well, I will like to argue on that also, my lord. But first, my lord, this first hurdle, my lord, the first aspect of the argument, which is, my lord, the procedure has not been adopted. Now, when the procedure has not been adopted, my lord, then in my lord, if my lord lordship is satisfied, then my lord, I don't even have to go through the evidence. If lordship is satisfied that I have been prejudiced, my lord, I was not given a fair trial, my lord, then the question
Our
of going
satisfaction we can record only after passing judgment, isn't it?
Absolutely, I'm just.
So, are you trying to get first judgment on the procedural aspect
No, my
and
lord.
then second on?
Well, it's similar to the BSF Act, my lord. There is something.
You have to argue on the same thing.
Yes,
See, like complete.
yes.
And then where we confine that we will
Well,
see.
if I start the evidence today, my lord, perhaps I will not be able to finish. So, my lord, I will prepare a note specifically on the contradictions, and then I'll place it before.
You raise your points of law also in that.
That also, my lord. Those 2 points of law, and
You
if I
do
can
not have to elaborate it, but then just give.
just bullet points, my lord. And if you, my lord, but we can have this in a very early date, my lord, if possible.
We do not know what will be the situation here and also.
After Tuesday. After, I mean.
So we'll have to
close to
probably by the end of next week, or maybe by next week.
We can have it next week, my lord. Just 1 week, my lord. Because the person is still in custody for the last 4 years. My lord. I have some merit in the case also. I'm sorry, my lord.
What is the sentence?
7 years, my lord.
He's already more than 4 years.
4 years, my lord. In fact, lordship can, my lord, at least suspend the sentence, and my lord, we can go for an elaborate hearing also. Because, my lord, in fact, this person was allowed to go on bail twice. And he has not jumped bail. He has come back twice. His father passed away. His father was seriously ill. Lordship had allowed. And well, there's so many judgments of the Supreme Court also, my lord. Recent ones also.
50%, more than 50%. No, but then we are at the final stage now.
My lord, because thereafter, my lord, we may have a very elaborate argument, which is very interesting also. It's the first time I'm arguing a case of this nature. It's also a learning experience for
We
me.
can conclude the argument anytime, my lord. I'll not take much time. Because both the points raised on procedural aspect, my lord, I can.
Yes, but then what happens in the evidence thing and all that you are yet to know. Let him raise the price. Okay. So we'll have it. These things we'll see what happens, because bail part, once we are in the final thing, then.
So we can have it next week, my lord. We'll try to wind up everything next week.
Hard. Learned counsel paying for the parties. Step. Mr. Gautam, learned counsel, appearing for the petitioner submits that petitioner may be allowed to submit a gist of points of argument on behalf of the petitioner may be allowed to submit a written gist of points of argument raised on behalf of the petitioner before this court proceeds further with the hearing. Dr. Maji, you can, if you like, you can also, of course, you will know, come to after he concludes that only. You will know. Yes, Dr. Mojika has no objection to the prayer made. What is it? Yes, so answer. Okay. Okay, this is Dr. Mojiga. Mr. Sensor has no objection to the prayer made. Then it's a prayer allowed. This is matter after 1 week.
Item number 18.
Please make the court acquainted with this procedure system. Yes. Another criminal matter?
Yes, Your Lordship, that privileged communication here.
Telephone was intercepted, man, and on the basis of that.
Okay. Disclosure of privileged communication.
Yeah, privileged communication, yes.
What happened? The trial court?
Trial court was directed to produce all this communication. What CBI is wrote to Ministry of Home Affairs, because only Ministry of Home Affairs can direct for tapping of telephone bill.
No, but then the privileged communication, basically, is it not a communication between the lawyer and the...
No, but there's...
Okay, there are certain.
There are.
Yes.
So, under Telegraph Act, there are for
Yes. Okay. Yes.
This matter can be taken up after 2 weeks, Your Lordship.
Mr. Kamal Agarwal.
A prayer made by Mr. Abraham Learned Counsel appearing. Here, there is how many respondents are there?
Only one sole respondent, yes, Your Lordship.
Paying give the respondents. List is met after 2 weeks. Yes.
Highly obliged, Your Lordship.
19.
Yes, their adjournment was sought in this matter by...
Lordship, the difficulty is we are supposed to file an objection on their application, misapplication. The petitioner is from Rajasthan, Lordship, that's why it's taking some time to get it front and back. I'm praying for 3 weeks, Lordship, if Lordships are pleased to grant it.
No.
Just say in the criminal miscase 80, which is this order. You just say, Mr. Deb Lanak Counsel appearing for the respondent number. You are appearing for respondent?
Number 2 in the miscase.
Praise for grant of.
In the main petition, I am for respondent number 2.
Okay. We are passing order in the miscase. That is why you see there has to be use of terms like opposite party and respondent, you see, just to avoid that confusion. And the lawyers should be, you say, like more acquainted with that aspects. Where to say applicant, where petitioner. Okay, so the Lanak Counsel prays for grant of some more time for filing of objection. Stop. The Ms. Bhattacharya Counsel is paying for the applicant has no objection. Prayer allowed, list after 3 weeks. And the main case also, list along with miscase number so and so after 3 weeks. Yes.
22.
please, Your Lordship.
Yes.
Lordship, this is a civil revision petition that we have filed.
Yes, Mr. Shilla, how are you?
I'm doing better.
Yes.
Hello. My Lord, this is a civil revision petition against an order passed by MACT July. Fairly straightforward matter, my Lord. If Lordship allows, I'll just...
Very straightforward matter.
Fairly straightforward matter. Fairly straightforward. What has happened basically in this matter, my Lord, is that we entered appearance slightly late. We received summons. We missed the next date.
MST.
In MST, Joy. We missed the first date of appearance. On the next date, we appeared. By then, matter had already, there was already an ex parte order against us. So we filed a petition to vacate that ex parte order. Should not have been filed, actually. I'll place the law also. But in any event, petition was filed to vacate that ex parte order. 1 year later, petition was heard and petition was rejected. Cost of 10,000 rupees was imposed on us. So it is against that order that we have come by way of this revision petition. So if Lordship allows, I'll just place a few dates which are relevant, which are crucial for this matter. First relevant date, my Lord, would be 20th March 2023.
You have submitted a list of dates, probably. Is it that?
There is a list of dates, but I'm afraid it's not a very comprehensive list of dates. That is at page...
That is a separate sheet you have submitted?
Yes, my Lord. That is at page 3. But there are two dates which have been missed in this list. That first date is, my Lord, 20th March 2023.
Notice served on insurance company.
Yes, my Lord. The notice was received by us on 20th March 2023. That is at page 47 of the petition, my Lord. Page 47 of the petition. This is the notice.
Page 47.
Yes, my Lord. Page 47 is the notice received by us. Date of receipt, Lordship will see, is on 20th March. And in the middle of the notice, Lordship will see...
The seal. You are referring to the seal. Yes,
the seal,
yes.
seal, my Lord, the seal. 20th March 2023. Yes. If Lordship sees the date of appearance, which was fixed somewhere in the middle of the notice, 12th April 2023.
Yes.
So, notice received on 20th March. Next date, which was fixed, was 12th April. 12th April, unfortunately, my Lord, there was no appearance from our side.
Okay.
Thereafter, my Lord, 30...
It was a default. The default started from there.
Yes, my Lord, yes. Thereafter, my Lord, 31st May was the next date fixed, 31st May 2023. There again, on that day, again, unfortunately, my Lord, there was no appearance. Ex parte order was passed against us by Judge MACT. This was 31st May 2023.
Yes.
The very next date, my Lord, on 6th June 2023, we entered our appearance through our local council there. We entered our appearance on 6th June 2023.
Yes.
Petition to vacate that ex parte order, my Lord, was also filed. That was petition number 59 of 2023. That is at page 43, my Lord. Page 43.
Yes.
So this was the petition that was filed under Order 9, Rule 7 CPC to vacate that ex parte order of 31st May 2023. Why I had stated, my Lord, very humbly that...
The petition doesn't show the date.
It doesn't, my Lord, but I don't think there's any dispute. This was on 11th September 2023.
Yes. This date is not disputed by them.
I don't think so.
Yes.
I don't think so. 11th September 2023. Okay. Now, my Lord, why I had submitted some time back that this petition actually should not have been filed in reality is because, my Lord, from the date of the ex parte order, that is 31st May 2023, till the date of filing of this petition, nothing had happened in the case. So, Sangram Singh's judgment, Lordship is aware of that even if there is an ex parte order, I can appear on a subsequent date and continue from that stage itself. It is only if I want to rewind the clock, something may have happened in between. Witness may have come and deposed. I want to cross-examine that witness, for example, then I have to file a proper petition, give sufficient cause, etc., and then hope to get that ex parte order vacated, enabling me to cross-examine or do whatever is required. In this matter, my lord, from 31st May 2023 till the date of filing of this petition, in fact, till today, I'm informed by my friend, nothing has happened in the matter. So this petition was filed. It should not have been filed, but in any
Anyway,
event,
once you have filed, then that is gone.
Yes, my lord, it was filed. Now, subsequent to the filing of the petition, my lord, there was an attempt between the parties to try and settle the matter, because it was a property damage claim filed by the claimant. So there was an attempt to settle the matter. That settlement process took some time, and unfortunately, my lord, that settlement did not work out. I believe, my lord, that there was a difference between the expectation and what we were prepared to offer, my lord, in terms of the compensation amount. That settlement did not work out. The learned MSCT was informed of the fact that settlement has failed. Judge MSCT, my lord, on that very day itself, decided to take up my petition for vacating the ex parte order.
Now, this, so far as the settlement between the parties is concerned, is it recorded anywhere in the authority of the court?
My lord, the impugned order itself makes a mention of the fact that the settlement was being attempted between the parties, and settlement has failed, my lord. If I can take, my lord, through the impugned order, that is at page 55, my lord.
Yes.
My lord, para 6, if lordship looks at,
Yes.
this tribunal has brought to the notice of OP Insurance Section 149 of MV Act 1988. It appears that the OP Insurance has been seeking time ever since this application is pending for hearing under the guise of settling the matter. Matters cannot be kept pending.
Under the guise of, that is what the thing is that.
Lordship,
That is a very critical way of writing, isn't it?
It's an unfortunate way of.
You see, it will not support your contention that it was.
Again, my
it
lord,
means that there is no genuine settlement attempt.
Again, my lord, I don't think there's any dispute between the parties that there was some attempt at settlement. Now, whether it was a mala fide attempt or a bona fide attempt, my lord, that with respect to the learned MSCT and judge.
See, there is no question of mala fide or bona fide here. It is a question that plea which is not very serious.
Yes,
you see, like something like that.
Because these MSCT matters, my lord, especially if it's
maybe on the pretext of this. Yes. Anyway, whatever it is.
Lordship, because ultimately, I mean, to be realistic, my lord, MSCT matters ultimately insurance company has to pay. So
welfare legislation. So why don't you pay now? Make some negotiation.
Lordship,
we are ready to sit again.
If claimant is ready, my lord, I'll take instructions. But I'm certain
do that. Why to come into those technicalities?
I'm certain that even the
Mr.
insurance
Jindal, you know, one thing is that the court will not be bound by the technicalities. In
no, absolutely, my lord. I'm completely in agreement.
So this way, that way, whatever way you have to pay.
At some point.
So instead of wasting time here.
Yes, I'll take instructions because I was not the conducting counsel there. What was the issue? Was it a difference in quantum?
Or a mediator will help you.
Because so far as the settlement before the trial court was concerned, my lord, the trial court has brought to the notice of the insurance company about Section 149. Section 149 clearly says that whenever the insurance company comes to learn that the claimant are claiming, they have to appoint an officer, and that officer have to take steps for settlement. Thereafter, my lord, after the learned MSCT tribunal has pointed it out, we were waiting.
But then they did not appoint any officer.
In fact, what has happened is Section 149.
Quantum was not an issue, my lord, but the issue was for officers to be appointed so that we can sit and discuss. So because of that, perhaps the learned trial court has passed this order.
So it means like there is no negotiation between the parties so far as the quantum is concerned.
So that's why we are ready, my lord.
My lord, in that case, my lord, I will communicate with the insurance company. I'll put in my best efforts to try and settle this matter.
Yes. Hard learning counsel for the parties. This matter pertains to compensation claim for motor accident. It appears from the submission made by the learned counsel appearing to the parties that there may be there are chances that there is a chance of amicable settlement between the parties insofar as the claim of compensation is concerned. Okay, since the learned counsel for the parties are willing to facilitate negotiation between the parties, come on, the matter is adjourned. The Mr. Jindal, learned counsel appear for the insurance, or shall we say that you will take up the
Lordship, if I can humbly suggest, my
since
lord.
so matter is urgent, to enable the parties to explore the possibility of an amicable settlement of the matter. Stuff as prayed for, list after 3 weeks.
Very well.
Please try.
Definitely, my lord. My best efforts would be put in. Just one aspect is there. The impugned order, my lord, has imposed a cost of 10,000 rupees on us.
That also you can negotiate. So once you come to these things, make it a part of negotiation.
No, we may not.
Once parties negotiate, then we can interfere with that.
Very well, because it may require judicial
Just
direction.
keep it
to-
in your mind also when negotiating
Yes, yes.
about the cost part.
Yes, yes.
Have a discussion on that also.
Yes.
Yes. Nothing more.